I spoke in a previous video of an anti-subordination principle in the Constitution, and I contrasted this with an anti-classification principle in the Constitution. And because we've been discussing the Supreme Court's decision in Calais v. Louisiana, which is based on the Equal Protection Clause of the 14th Amendment, I figured I would talk a little bit about that casually while I walk the dog, one of our regular walk and talks. So first, a little historical background. The 14th Amendment of the Constitution was ratified in 1868, but Congress began formulating it in 1866. It is a direct response to the immediate conditions of the Civil War. Section 1 of the 14th Amendment is the most important section of the 14th Amendment, although they're all important in their own reasons, but Section 1 is the one that we focus on. Section 1 establishes birthright citizenship. It establishes that all citizens shall enjoy the privileges and immunities of American citizenship in the states and throughout the country. It establishes that all people shall receive due process of law in the states and throughout the country. And it establishes that all people shall have the equal protection of the laws in the states and throughout the country. Now, the immediate context under which all of this is happening is, of course, emancipation. The 13th Amendment to the Constitution ends slavery. 4 million enslaved Black Americans are thus allowed to try to live their lives, and they run into immediately the effort of the former Confederates, the ex-Confederates, we want to call them, to try to reimpose something like the conditions of slavery. These are the Black Codes, which you probably remember from school if you've not read about that since then. The Black Codes very explicitly are trying to recreate the social system that undergirded slavery, in which Black Americans did not really enjoy much in the way of any freedom and were fully subordinate to and tied and connected to a set of white masters. Republicans in Congress thought this was intolerable. These were very different Republicans. And passed the Civil Rights Act of 1866, which attempts to deal with some of this. The Civil Rights Act of 1866 has the first iteration of a birthright citizenship clause, and it also outlaws discrimination in the making of contracts, which was quite pertinent because what was happening was that Black Americans were being forced into these unfair labor contracts. Andrew Johnson, the president, vetoes the Civil Rights Act of 1866, saying basically that it's an unfair handout to the blacks. Sounds familiar. Congress overrides the veto, and they pass it into law, and the law's still on the books. But worried about their constitutional authority to do more than that, they begin crafting an amendment that really attempts to settle all of these questions of state and federal power, and of the federal government's ability to enforce civil rights and enforce the settlement of the Civil War. Now, unfortunately, the drafters of the 14th Amendment didn't say a whole lot about what they meant by the equal protection of the laws. They kind of took it for granted. And this lack of clarity opens up, obviously, a lot of potential for interpretation. And there are basically two competing interpretations of the Equal Protection Clause. Competing might be too strong. Two interpretations that are sometimes competing, sometimes complementary. The dominant interpretation, and the one that was deployed in Calais, is an anti-classification interpretation. That interpretation says that the Equal Protection Clause makes it illegal for the government to engage in arbitrary classifications, race being paramount. You can't distinguish when it comes to lawmaking or what have you, you can't distinguish between citizens on the basis of race. Or if you must, it comes under very strict scrutiny, which is a standard that emerges in the 20th century. Sounds good, right? The trouble comes when the government wants to deal with the consequences of past discrimination. Because to deal with the consequences of past discrimination, you have to actually identify who was discriminated against. And because the nature of invidious discrimination in our society is group-based, you have to classify by groups. And so policies that classify by group come under immediate constitutional scrutiny. And while liberal justices were basically willing to say, yeah, that's fine, we can see what they're trying to do, conservative justices were much less forgiving. And so really beginning in the 70s, we get jurisprudence, which does draw, again, like a logical equivalence between the various kinds of discrimination. And Clay v. Louisiana, in fact, has its origins in a 1981-82 ruling in which the court basically overturns a set of measures meant to try to prevent discrimination or discriminatory effects by stating two things. First, that you have to have discriminatory intent, right? You have to be able to show that someone is trying to discriminate. And second, if you can't do that and instead try to say, well, this group is harmed, that may well violate equal protection. So that's anti-classification. And one way to think about it is as if the Equal Protection Clause did not read equal protection of the laws, but protection of equal laws, right? The laws are equal for everyone. The other way to understand equal protection is by taking seriously group disadvantage. And this is the anti-subordination view. And the story of the anti-subordination view basically goes like this. The issue the Reconstruction Congress faced wasn't that black people were being classified. The issue that they faced was that black people were being subordinated by people in power. Former Confederates had retaken power and were using that power to subordinate people, to keep them as a lower caste. And so, to remedy this, to prevent this from happening, you had to ensure that all Americans would be protected by the laws equally. Now, this is tricky because not all Americans are in the same place. And so equal protection may mean different things for different groups. Equal protection for the formerly enslaved may look different than equal protection for their white fellow citizens. Under this reading, you can classify, and there would likely still be some strict scrutiny involved. You can classify, but it's not immediately verboten, right? You can classify based on what you might describe as the groups that you sort of know exist in American society for the purpose of remedying past forms of discrimination. You could also describe this as substantive equal protection, an equal protection paradigm that's very much based on making sure you have something like fair outcomes. When in 1982, Congress amended the Voting Rights Act in order to ensure fair representation for minority groups, they were operating under basically this assumption. It was a recognition that because it's very difficult to prove intentional discrimination in voting, most of Jim Crow, in fact, was not explicitly written against black people. These were neutral laws, facially neutral. It's very difficult to prove intentional discrimination. And it's very easy, as we're witnessing right now, to redraw maps in such a way as to effectively eliminate a particular minority communities, especially when those communities, for discrete historical reasons, tend to support one party over the other. And so the creation of the majority-minority district is a prophylactic of sorts. It is forcing states that might be inclined to engage in that dilution or destruction of voting power to instead enable those voters to get fair representation. Because otherwise, given that they are in the numerical minority, and given the connection between their minority status and their political minority, they likely would not get an opportunity to get that representation. So in this case, the government is recognizing an existing classification, affirming it, and stating that it is relevant to this substantive goal of giving people equal protection in the political system. Now, I said at the start of all of this that these things aren't necessarily in conflict. They're not necessarily in tension. You can have an anti-classification standard and an anti-subordination standard, and it just sort of, depends on what you're trying to do. But what the conservatives on the court are doing is trying to write the anti-subordination standard out of the constitutional order and only have an anti-classification standard. And that anti-classification standard then is utilized to prevent any efforts from trying to ameliorate past discrimination. It holds instead that unless you can definitively prove an intent to discriminate, which is, again, would have been difficult even at the height of Jim Crow, unless you can prove an affirmative intent to discriminate, then there's not really much you can do. What this has the effect of doing is allowing for the continuance of existing discrimination and existing inequality. And it gives people who wish to engage in discrimination, like actual harmful discrimination, an easy basis from which to do it. They just can't, put pen to paper. They can't say it in front of a camera. Now, people will tell you that this is fair because you're not treating people differently based off race. And here, I would point you in the direction of a little book by two scholars, Barbara and Karen Fields, called Racecraft. It's a collection of essays. And one of the key insights of the book is that we make a fatal mistake when we use the language of treating people differently according to race. It suggests that race is somehow compelling treatment rather than people actively engaged in discrimination. And it allows for what I would describe as the sophistry of this Supreme Court, of treating discrimination meant to subordinate people as equivalent with discrimination or with just different treatment meant to address that subordination. There wasn't a Freedmen's Bureau for Southern whites. Was that unfair treatment? Was that discrimination? Of course not. There wasn't a Civil Rights Act for white Americans. Not that the Civil Rights Act doesn't apply to them. If you are discriminated against in a harmful manner, it very much does. But we didn't have to pass a Civil Rights Act in order to deal with unfair treatment among white people, because that kind of invidious racial discrimination isn't really something that is common to the white American experience. There is not, and never has been, pervasive anti-white discrimination in American society, no matter what certain people, like the president, happen to say. Trying to have a diverse workforce, trying to have diverse college admissions is not anti-white discrimination, right? Another way to put this, I keep giving you other ways to put things, is that the colorblindness of the kind embraced by the court is less about ensuring equal treatment and more about ensuring that the government cannot touch unequal treatment. That unequal treatment is relegated to a shadow realm where federal power, or state power, or even private power cannot intervene. Because as soon as you are attempting to deal with genuinely unfair treatment with people, you have to identify which groups are being subordinated. And there you have a classification. This has gone very long. You've been with me for more than a mile thus far, so we're going to cut it short. But that is my attempt to try to give you some explanation of the differing equal protection paradigms. And I will say that I very much think that the history and the text and just common sense suggests that equal protection, due process, that these amendments are tuned to the problem of subordination in our society, that they write into the Constitution an anti-subordination principle, and that the government should be allowed to address subordination. In the case of voting rights, that means the government should be allowed to consider if a majority-minority district is appropriate for ensuring that people have equal representation. And there are many other implications to embracing an anti-subordination view of what these amendments do. Because that is the aim, not simply for people to not be treated differently, but for people to not be ranked according to hierarchies and castes, for no one to be on the bottom, and for no one to be on the top either. To borrow from Abraham Lincoln, what is freedom to me? Freedom is that there shall be no slaves, and also that there shall be no masters.